Fantastic. Just making sure we are live. Yes, we are live. And today on this Courageous Conversation, we're going to be talking about such a good topic about legally protecting your brands. My name is Barbara Bolton Schreiber, and I am the founder of Sisters Rocking Courage. And what we do with Sisters Rocking Courage, if you don't know, is we really encourage women to step into their power, to spread hope, make an impact, and create financial independence. So why is this important that we would be talking about protecting our brand? Roya and I were just talking about it. She and I were introduced through a mutual friend, Cranford. And so it was just a fantastic timing, because timing is everything, because I had some questions about protecting my brand too. So Roya, please do introduce yourself and even maybe where you're from. It's fun.
Of course. Hi, everyone. My name is Roya Sayadi, and I am from Iran originally, but I'm raised in Sweden and I'm living in Barcelona.
Oh, wow.
So it's a cocktail. Yeah.
Sure.
There will be information you don't know about, Barbara. So, but I have lived in several major cities around Europe and just worked in some major companies in different roles, leading roles across Europe. London, Amsterdam, of course, Stockholm, and then now I am in Barcelona. I actually lived also a very short period in Munich.
Oh, wow.
So yes,
Mm-hmm.
I've traveled a lot when it comes to just living.
Oh, fantastic. So there's a piece of this with you. So you started Sayadi Law.
Mm-hmm.
And how did that come to be?
Oh, it was mid-COVID. The law firm I used to freelance and work for, they decided, I think fear struck in. So they decided to change my contract per se. And I just felt so disposable. And that was when I had enough. I was like, I'm going to start my own company and intellectual property law firm. I love what I do. And just to help clients protect their business, it's so inspiring to see everyone creating these amazing projects, products, and to be able to protect that for them. It's just very fulfilling. Mm-hmm. So that's how it all started. It was kind of an impossible mission at first. I just took a decision. I didn't know the how, literally. And it all starts with a decision, right? So that's how it started.
So your decision was that it was very important. You were passionate about protecting other people's property, so we can go and do what we do best, right?
Exactly.
Yeah.
During working for my previous firm, what I realized is that most businesses, they didn't have a protection for their brands. So you spend so many years, so many months, days building up a brand, and then what do you forget? The most important, protecting it, right? Mm-hmm. And that's what I realized. I used to do, I think I've done over 3,000 analysis of portfolios. So it is safe to say that most businesses didn't have a protection, or the ones that did have, they actually had an inadequate one.
Right.
So it's all comes down to awareness. People are not aware about this topic. And as they're lawyers that normally protect the businesses, they do not go out and give presentations. They know the legal side, right? Mm-hmm. So as a business owner, you go to a lawyer and you're the one who are actually supposed to let them know what you want to do and what you want to protect.
Right.
But what I also figured out is a lawyer normally doesn't know how to protect a business. They know the legal side. So you need an entrepreneur, a business person who can look at your business, holistic and proactive approach, and tell you how to protect, because they know, because they do what you do. Basically, they're a business owner.
Right. That makes a lot of sense, because we get to a space, especially for those of us that are selling a service versus a product. But you even talk about how having your incorporation, how your name can be a challenge in different countries. But even product, like when you're coming up with the name, we think about it in a small space, but when we start to, because we're all on the internet now, you know this too,
Mhm.
we're all on the internet, so our space isn't just a local community. We don't have to just check, we're in the United States, so we don't just have to check within our state anymore. And so when you were talking about thinking entrepreneurially, like what we're doing here, especially creating a service and putting a name on our service, doesn't just apply to the state that I live in.
If you're selling your services outside of US, you don't need to have a local presence anymore. So as soon as your product or your service is being delivered in another country outside of US, you're actually present in that country. So you need to protect or at least do a trademark search on your business name, your products, or any service that you provide that is under your brand, so that you're sure that you're not infringing on someone else's market. That could be costly, right?
Right.
And that could prevent you from selling your goods and services in that specific country if you don't know.
So in the past, people have said, well, I'll go ahead and then wait for the cease and desist letter, right? But what happens, like the cease and desist letter, again, you've put all your blood, sweat, and tears into something, and now you're going to look at pivoting. Is it as simple as when somebody says you have to stop selling? But what if you have a product that you've already imprinted your name all over everything?
That is why you need to protect your brand before doing any campaign or launches, because that's costly. You're spending so much money on producing products or creating a campaign. We all know marketing costs. So
Yeah.
you're spending so much money and effort and time on that. And to just realize that you're not allowed to actually put it out there in the world and you have to take all of that back, that is frustration. It's just the headache and anxiety that also gets involved. So always make sure you do a search. And also something important that people need to understand is that different countries operate on different laws.
Mhm.
For example, in the US, it's first to use that's gives you the right to be the owner, even if you haven't registered your brand or your trademark with your trademark office, but you're first in commerce. So you're selling your product first in that country. That gives you the right. So you're the actual owner. But in Europe, it is the opposite. It's first to file. So even if you have been in business for 4 years and somebody else comes and files before you do, you need to rebrand. That's what's going to happen. So if they start 3 years after you and they do the exact same thing, because they're allowed, right?
Right.
And if they get the protection from the trademark office, then you're the one who are actually supposed to rebrand. And the average infringement cost is around $150,000.
Wow.
Yeah.
For an infringement
That's
cost.
the average.
So it's not just cease and desist. It's you're already in trouble.
No. Yeah, it depends if you can come into an agreement with the counterparty that's actually sending you the cease and desist. There are so many cases, so many brands, just that big brands that are in problem. I don't know if any of the listeners have heard about the Tiffany vs Costco.
Oh.
So Costco was selling an engagement ring called Tiffany's in their store. So there was a client of Tiffany's that went into the store and saw that and actually wrote Tiffany's, I cannot believe you're selling your, brands in Costco, which is a low cost, right? Business. So, and Tiffany understood it, so they took Costco in court. What ended up happening is that Costco had to pay every penny they made plus damages up to, I think they made about $6 million on that, selling the engagement rings. And they had to end up paying $18 million to Tiffany's just because they used the name Tiffany's for an engagement ring. And Tiffany's was the owner.
Yeah.
So these are just cases that can happen. And if you're a small business owner and someone who has the finances, who comes and just loves your branding, loves everything, and creates that and register everything before you do, then yeah, you need to rebrand.
But you're talking about registering in different countries. So, well, and another good example that you had was like when Burger King wanted to go to Australia.
Yes. As soon as, I mean, registering in every country, that's going to be expensive because each country have their own trademark office, right? So the advice isn't always to, if you're a small business, if you have the budget, go for it. If you know you're going to be active in that market and that market is going to be one of your major ones, you should definitely go ahead and protect that. So the case with Burger King, yes, many people don't know that Burger King is not called Burger King in Australia today. It's called Hungry Jack's because someone actually owned Burger King. And it's a country that it's first to file. And yeah, they decided to not to buy the brand, or the owner of that brand who registered it wanted the name Burger King. So today, if you go to Australia, you cannot, look for a Burger King. If you want to have a Burger King burger, you have to go to Hungry Jack's.
Yeah.
So expanding, it's all about strategy. And that is why it's good to have IP strategists, consultants that actually takes care of your portfolio, because they know strategies and they know how to expand in which countries and markets. That's going to be time and cost effective for you to protect it. You need to customize an IP portfolio according to your business needs. That's also something that's very important. Every business is different. Something all clients or potential people that want to protect their brand needs to take into account.
Well, it's one of the things I say to people, to the clients that I work with, is really focus on what your area of expertise is. And so when we're focusing on our expertise, like bringing in your team, building your team for other people to do what they do well, because it can be overwhelming to think about legally protecting your brand. What I've experienced recently is, as we get stronger in what we do, and how we say it, for those of us that are doing service, is what is it? Flattery is the largest compliment, is the greatest compliment, right? So as we get out there more and people start sharing our work, infringement starts to happen. There are people, and it's common conversation in our circles. What do you do when people start using your language to sell their products? Or even your entire slide deck. Let's just go there. So you're at an event, you do something public, they're taking pictures on their phone, and then next thing you know, it does come back. Customers will contact you and say, hey, or clients or friends and say, hey, I saw your work in this location.
Yes. And normally when you create a brand, you want to have the exclusivity, right? That's what the point is, to have a brand. So if the more you allow other people infringe on you and use your branding, the less power you will have in the future of being the rightful owner of that creation. So what you need to do straight away is the C&D letter, cease and desist, so that you make sure that they stop promoting under your name, basically, and doing business under your name. That is the first step of everything. It is the cease and desist. If they won't stop, most companies, they actually stop because of the fear of getting sued. So they end up stopping using your brand. But then there are certain businesses that actually go the extra step and sue the counterparty. If they've made money out of it, out of using your brand, you're the rightful owner of that. So I always say that protecting your trademarks and copyright, it's not a liability, it's an asset, because there's so many different ways you can make money out of your intellectual property rights. You can license it,
Yes.
I mean, Disney alone is making millions, if not billions, on just licensing their characters or their name. So it is an asset, and then it adds value to your company. It adds that you're actually a serious business owner.
Mhm.
And also investors, if you're thinking of getting investors on board your firm, what investors, serious investors do is making sure that you're protected.
Mhm.
If not, they know the headache that comes with not being protected legally.
Right. And so there's another piece of that too, even the NDAs, just making sure that when you're talking to potential partners, that there's non-disclosures where just in so often, and I'm guilty of this, so often I get excited and I start talking with somebody and not even having that safety precaution in place, that you could be talking with somebody who could take your idea and run farther with it than you are right now. And so that's another piece.
Yes, if you have a great idea that you know, I mean, you shouldn't discuss that just openly and just naming the whole process or the name dropping of what you're going to actually call it. You should actually not do that unless you filed for a trademark. And then it doesn't matter, then you can openly discuss. But when it comes to a business idea or something, yes, to speak to potential collaborators, you should have an NDA in place. That is always advisable, because that's going to give you protection for future problems, right? We don't go into agreements with people to wanting to sue them later on. We just go so that we know, what the outline is, right? This is my responsibilities. These are your responsibilities. And it's just to make the collaboration much smoother and easier, and that it works. So if it's not a shady person, they would sign an NDA, and that's it, because there's not much into it.
Yeah, they would sign an NDA. And if they don't, then that just tells you that you were actually doing the right thing, that having that in place is a good thing. So what do you say to people who, two things. First question is, you're in Barcelona. How do you help people that are in other countries?
We register globally, so it doesn't matter. About, I think, 30 lawyers within I have for the firm that work all over, local lawyers in different countries. So we know the laws in different countries. It doesn't matter where you're from. I have clients from the States. That's the interesting part. And most of my clients lately are coming from the States, because people from the States are much more aware about protecting their brands. And that is because it's easier to get sued there, right?
Yes,
in Europe, it's different. It's different. So it's less awareness, and it comes a little bit in after. But I have clients that before launching, they are actually protecting their businesses. They get in touch with me, and it's super important for them, which is great, because that's how it should be. Before launching, you should protect it. So we work globally. It doesn't matter where you're from, where you have your business registered, and it doesn't matter where in the world you want to register, because we work remotely as well. It's a cloud-based firm, so we can help you anywhere you are.
Yeah, and so there's that piece of it too, where a little bit of myth that comes into it, where it's too hard to maintain your trademark, or it's too well registered, because the TM and the R are different. But the myths about, like, the way the world is now, there isn't a way to really protect it. What do you say to people who say that?
What do you mean with there isn't a way to protect it?
Well,
because
that it
we're
would,
now online.
with us being online, like, what are the laws that protect it from online? That's the one part of it. And the second part is being able to protect it in other countries. It becomes very expensive. I think when you register a trademark, once you go through the process, it's like, what, a 10-year protection?
Exactly. I mean, normally what it costs a business, you need between 2 to 3 classes to protect your brand in, your business in, and that would cost you anything from 2,000 to 2,500, right?
Mhm.
Dollars, US dollars, depending on how many classes you want to include. And that protection is valid for 10 years. Every 10 years, you have to renew your protection again. As long as you use that trademark, it is valid.
Mhm.
If you stop using it, then it becomes invalid. And yes, as I said before, it is costly because we're going online to protect it in every country. That's why you need an IP strategist who can just calculate all of that for you,
Right. Yeah.
because you need to protect your business according to your business plan. It goes hand in hand. If
Mhm.
someone else tells you something else, that is not true, because you need to have the IP protection of your firm going hand in hand with your future plans of your business. And you
Mhm.
need to be a step before even launching that business so that you have the protection in place.
Yeah, and you make it really doable. I like when you talk about your strategists, because that is also another piece that we don't have to be thinking about. We can just say, here's what our next plan is, and then your folks can look and see what would be best for that.
Exactly. We provide solutions. This is what you should do. This is how it should be done. It's kind of like a 1, 2, 3 step process. That's
Mhm.
it, simple. And we are the ones, by just looking on a website, I know exactly what you need, what kind of protection you need, because we are specialized in that. You don't know what you need because that's not your field to know. You're an entrepreneur, a business owner. Your focus is in success and growing your business, right? Making money.
Mhm.
And my job is to protect that money.
Right. Right.
So that's why those strategies, it's all about understanding the operation. And it doesn't matter which sector you're from. You could be pharma, it could be coaches, because a
Sure.
coach needs to, it doesn't matter. You need to adjust according to the sector.
Mhm.
But in the end, yeah, we just look through, you tell us what your plans are. And we always say your 5-year plan, basically.
Sure.
What are
Yeah.
those? And then we protect it alongside that.
Yeah, we have Elka from Germany who's saying, what is an NDA? That is the non-disclosure agreement. And then what does an NDA do, Roya? Since you're the expert, I can tell them, but yeah.
An NDA, basically, when you're going into a meeting with someone, I'm going to say it very simple, and you have that person signing an NDA so that every information, everything that is said during that meeting is not being disclosed.
Mhm.
So that it's the information is not leaked, to
Yeah.
say. So that it is confidential, and it kind of puts your responsibilities that this is a, if let's say the agreement between you doesn't work out on later, you're not coming into an agreement, that person is still not allowed to disclose any information.
Right.
And
So-
so
then-
it protects your business.
They're not allowed to take any of the information from that meeting and then go and make money based on what was discussed.
Exactly, or promote it,
Mhm.
or anything that has to do with that information being leaked out.
So let's say you're looking at forming a partnership.
Mhm.
Within a partnership with 2 different people, it wouldn't exactly be an NDA. What would that be? Well, I guess it could be a non-compete.
Oh, you need a partnership agreement.
Partnership agreement.
If
Mhm.
you're going into an agreement, then you need a partnership agreement. And a partnership agreement is, I mean, any agreement, it's just the best thing you can do for yourself, and it's a headache you will save. It is, again, nothing to be used most of the time, but in case a problem raises, then you guys know your responsibilities, because in the agreement you outline what your duties are, what the partner's duties are, and what your responsibilities are.
Mhm.
So in case of an issue, you will always fall back on the agreement and be able to solve it from there.
Mhm. Well, and what's nice about this is, yeah, can you go online and Google and find agreements that you adapt? When we use a firm like yours, it's already taken care of, it's off the plate. And when you start looking at how valuable your time is with creating, what is your business plan? What is the next step? Who is who are the people you need to be speaking with. When we are in our zone of genius and we bring in people like you to be in your zone of genius, when I hear you talk about, do this agreement, do that agreement, I'm like, yeah, I can figure out how to do that, but I don't want to. It's not a good use of my time, one. Two, you can plan ahead, look ahead. When you said that you've done 3,000 evaluations, you have other experience that really makes it be beneficial to us. I heard something once, I think the story is about Picasso drew like a artwork on a napkin and he wanted to sell it for 25,000. I don't know how true the story is because it's like the telephone thing, but he wanted $25,000 for it. I might even have the wrong artist, but somebody said, but you just put this on a napkin. And he said, you're not paying me for this napkin. You're paying me for all the years that I've developed this expertise. And so for you to use a firm that you have set up is pulling all of that expertise together. It just makes so much more sense, Roya. You have me sold. So there's a piece of this, like, tell us in your words why we shouldn't do this work on our own. This is going to be easy.
It is, yeah, it is because you're going to miss things. You're going to miss things about scenarios that we know for sure can happen.
Yeah.
So that is, we can predict and put that in the agreement. You can download, you can go to LegalZoom, which is very cheap, right? To get an agreement. But is that agreement customized to your needs, to your
Right.
business? No, it's not. And what clauses do you know that can be included for you? Most businesses, and as an example, I can tell you is that we have PayPal and Stripe, right?
Mm-hmm.
Most businesses, they use PayPal, but for service providers, PayPal is not a good way of charging clients. For service providers, because for 6 months that client can actually withdraw that money. You need, unless there is something in their clause that says you need to have it signed. Once you perform the work,
Mm-hmm.
you need to have the client to sign that they have received the service.
Right.
And how many businesses actually goes back to the clients when they perform the service, like, can you sign the document that you're happy and you received the service? If
Right.
someone's unhappy and
Mhm.
you've just spent 4 months on that client performing a job, because it happens, and the client is unhappy,
Yes.
then that person won't sign it, but they can actually go to PayPal and retrieve the money.
Mhm.
So, and PayPal comes to your bank account and retrieves that. So these are the things that contracts will cover. These are the things that having a law firm on your side
Mhm.
will tell you all of these things that is specific for your industry, whether you're a product-based firm or a service-based firm.
Well, and that's what I found, Roya, because so much of what we do is customized, because everybody has an idea now and you can run with those ideas. And to have experts that we check in with, because it is customizable. I wouldn't know what questions. It's that whole you don't know what you don't know. I think that's fascinating with PayPal and Stripe. Yeah. And it doesn't surprise me at all. All righty. So we've already talked a little bit about, what happens when business owners don't protect their brands. It really ends up costing them a lot of time and a lot of money, and honestly, a lot of energy and creative. It can really change the direction of your business. So what encouragement or challenge do you have for women who are watching?
Encouragement and challenge.
Yeah.
I would say, I remember when I started my firm, it just started with a decision. I took a decision. I didn't know how. My boss actually told me, you cannot do it. Which motivated me even more. Sure. But it was just that decision. My encouragement would be just take the leap, take a decision, be consistent with your decision. You just need to show up. You don't need to do a million things during one day. Like, you just need to do 3 good things in a day, and then get yourself a tribe of like-minded people around you.
Yeah.
So that's what I would encourage people to do that wants to start their business and get into business. And challenges is that when I started, I thought that I'm alone. Oh, it's so difficult. I'm alone. I don't know how to do this and that. Instead of thinking that way, just change that in powerful questions. Ask yourself powerful questions.
Right.
Okay, how can I do this to achieve that? Instead of saying, oh, how am I going to do this? How, oh, this is so difficult, because you're setting up for failure basically, right? And I told you this just before, it's normally not a business problem we have, it's a mindset problem we have. And I just realized during this weekend that, oh, I have no business problems, but it's the mindset. It's the mindset that normally just we take 2 steps forward and then 1 step back, 2 steps forward, 1 step back, which happens. And it's all in the mindset.
It is all in the mindset. Yeah. And that's a good tie-in, because the challenge that I would say too is to think bigger. And that goes back to the mindset, like think bigger. And part of protecting your brands is to think bigger. It is when you talk, Roya, about bringing in your team, create your tribe, that is so important, because when we surround ourselves with other people who are thinking bigger too, and protecting your brands is all about that, because every single one of us has a strong brand inside, and it takes the people around us and the mindset to really help that develop and come out in such a clear way. The more we do that, we all can think of, you do it all the time, we all can think of people that have powerful brands, right?
Right.
No matter what service or industry you're in, there's powerful brands. Go ahead, Roya, you were going to say something.
Exactly. When I started, the first thing, most important, was my branding.
Yeah.
It was what I was concerned about. I wasn't concerned about getting clients, because I already were working for companies and making them rich every day, right? Bringing in money for them. So that's not the issue. So for me, it was just like the branding and protecting my branding. I even filed for classes under my brand that I haven't started yet, like producing that. But I thought big, like huge, I started already globally. So I just went global from first day. So I'm getting clients all over the world, and that's it. It's all about thinking big, because the bigger you think, the more creative you become as well. The more and the tribe that comes into that alongside, it's just making such a huge difference. I am in different groups. I mean, Cranford and we met through a coaching group, which is in the States. And now I'm connected to literally 400 people in that group that are all over the world. And we are all on the same page. We're all thinking big. We want something more. There is a meaning, a purpose we're looking for, right? So thinking about protecting your brand, that's something you should start doing even before you bought your domain. Right. Even before you bought your domain, you should at least do the search and see if you're buying the domain, is it okay? Can you protect it? If not, the person who actually have the registered right can come and acquire your domain, because they own the name.
Oh, they can.
Of course they can. Your social media accounts, everything, even your social media accounts.
Oh, I thought once you had here's a myth. I thought once you had the URL, the domain name, that it was yours.
Registering your LLC, limited company, partnership company, it is different compared to protecting your brand, filing for your trademarks officially, and buying your domain. All three have different purposes. Your domain is basically you using that platform to sell your services or show your branding. But you're not protected. Just because you bought the domain doesn't mean it's yours. It is actually the trademark office that gives you the right.
Wow, that's so fascinating. So and you were even talking about your team will go ahead and start to see if there might be any potential challenges before you invest too much into it.
Exactly. We have actually something that is the clearance search, trademark clearance search, which means the name or logo, the brand that you want to protect, or slogan, whatever it is. We check the market, the database, internet, domains, everything out there, and tell you what chances of success is, what risk of confusion, similarities out there, and then we just give it to you in a report.
Yeah, so then
So
we don't, yeah.
And we never file high risk applications that we know you won't get any trademark for registration. It's just waste of your time, waste of our time, and waste of your money, literally.
So getting a unique domain name, now they've started to do things that you just put like a couple letters on the end or whatever, so you can still, because there's so many domain names that are already unavailable. So does part of your program work on creating what that domain name might look like with the brand, or does the business owner have to bring that to you?
What do you mean? You mean the website?
Yeah, so for like the website, so let's say somebody has an idea to create a community online, an online community, like a membership group. Do they already have to have the name choices that they're looking at to bring to you to do that clearance search? They do.
Yes.
Okay.
And throughout the search, we will suggest. So if, let's say, we do the search and the client, we tell them it's a high risk to file for it, we will help them to find an appropriate name that is similar to that name, but we can protect.
Sure. So it's a safer name.
We do help.
Got it.
So we do help with that as well.
But we still have to have the starting point. But again, this is why you're saying do it before you launch, not after.
Exactly.
So for some of us, it might be a little late. But yeah, but never think it's too late, right?
No. It's never too late, and it's better to be informed right now. Like literally go online and check it. Check on the trademark office, the respective trademark office in the country that you're at, and see what are filed or registered today.
Okay.
You don't need to pay attention on ended and expired ones, because those are not any threat to you, but filed and registered, yes. It doesn't need to be exact name as well. It could be a similar name to yours that could present an issue for you to get your registration.
Yeah. There was a question that popped up. Somebody had asked me yesterday, and I should have written it down, but because it related to copywriting. So because there was a question about like if the content was similar, but the actual name was different, like, can you use similar content? What does that look like? Because of, yeah, go ahead.
No, like copyright law operates differently from trademark law. So copyright law, as soon as you create a content, it is copyrighted. You're the owner of that brand. You only need to register it if you want to enforce it, or if someone starts using it and you want to sue that person, then you need to have that copyright registered.
Okay.
That's how it works. So if you have the same content, different names, in trademark, you're not infringing, but in copyright law, yes, someone is infringing on the other person, because let's say trademark is everything that has to do with the branding, and copyright is the content within that branding, right?
Right.
And it's two different things. So even if the name is not the same, but the content is the same, then it lands under copyright law, not trademark law. So it's separate.
Yeah.
You have trademark law, copyright law, patents, and then you even have trade secrets.
Oh, for sure. Yeah, the trade secrets.
So it depends. So yes, in this case, it's a copyright issue, infringement.
Okay. And so if you're creating a program like a formula or a system, so that becomes something you can trademark.
Well, the name, slogan, anything that has to do the name, yes. But if it's a formula, let's say it's a recipe, a cookie recipe.
Oh, that's a good
simple,
example. Yeah.
That's a trade secret. That's a trade secret. But if it's being reverse engineered with trade secrets, let's say someone figures out the exact recipes in that recipe,
Yeah.
then and they just come up with it, then your trade secret is invalid because someone actually figured out the recipe.
Oh, wow.
That's
Isn't
also
that-
something. Yes. And a trade secret is only a secret when it's kept a secret. So
Right.
if it's leaks, then it's not a trade secret and everyone else has access to it.
So Bush's baked beans, are you familiar with them? In the States, we have Bush's baked beans, and there's a dog that they use him in the commercial, and he's never going to tell them what's in the baked beans. No.
No, not that one.
I'll have to send you the link to that commercial. They're pretty funny. So yeah, that really helps with understanding what trade secrets are. But the sadness is that they can be reverse engineered. And so there's not quite the protection on that. Yeah, I had another question, but it kind of left. What else should our folks know? Oh, that was the question. Roya, your team does the business monitoring.
Yes.
Talk about
Yes.
that.
So let's say you have a trademark now
Mhm.
and you've registered it or you just filed it. So you want to keep the exclusivity. So you need to monitor that so that no one else files a similar application to yours. So that's what the monitoring is for. It's basically a tech tool that alerts us whenever someone files for similar, not just the exact similar
Mhm.
trademarks as yours, even if it's logo on a Google app, all of that is included.
Mhm.
And we will get an alert. So that tells us, okay, this person filed on this day for this name. So
Mhm.
we would bring this to you as our client and let you know and give our thoughts what we should do in this case. If it's something that, because you can protect your business in 45 clauses, your brand.
Sure.
Clause 1 to 35, up to 35, it's product based, and 35 to 45, it's service based.
Mhm.
So let's say you sell clothing under the name of Sisters Rocking,
Mhm.
and someone else is providing courses for
Mhm.
Sister Rocking.
Yeah.
It's two different sectors. So you're actually, unless your clients are going to be confused, you're actually allowed to use those in
Mhm.
different sectors.
Right.
You can both have protection.
Mhm.
However, in this case, if they're in the same class as you, we would advise that, okay, now you need to oppose on this application. Because we do not want to let this person to have a registered trademark.
Mhm.
Then it makes your brand less exclusive.
So Jody is asking, doesn't the trademark office check when somebody applies for a trademark and deny it if it's similar? What?
No, not everywhere. In the US, yes, that's what office action is for,
Mhm.
right? But in Europe, no.
Oh, wow.
No.
So somebody.
It's up to, yes, it's up to the brand owner themselves to actually trademark owner themselves to keep the exclusivity and have a monitoring in place. And also trademark office, what they do, I mean, it's an examiner, it's a person behind there, right?
Sure. Mhm.
So if they miss something, human errors happens. And then the other person gets a filed trademark, then you have to go and cancel that trademark. And that's going to cost money.
We have to cancel ours if somebody else gets one.
Theirs,
they do.
Yeah. If they get the similar one.
So is there a certain time frame that it's like public announcement that somebody is applying for a trademark, and that's the part that your team then steps forward with? Okay.
Exactly. So what happens is when I'm just going to talk about the states because there are different timelines and different opposition periods for
Sure.
each country.
Okay.
So in the States, it takes, normally used to take up to 3 months for an examiner to look at your application. Now, because of the high volumes, it's up to 5 months, they say. So within these 5 months, they check your application. And if everything is in order, there is no risk of confusion, they don't issue an office action, it goes up to publishing. So they publish it. Other firms have 30 days to oppose on that trademark. So you have 30 days to oppose on that brand. And if no one opposes it, then it goes to registration. So between 7 to 9 months it takes to get a registered trademark without any issues, if you're not receiving any opposition or office action.
So the quickest it can go is 7 to 9 months.
Yes.
Okay. Wow. Okay. So here's a question from Jody. Do you ever have to revert your trademark, and how does that happen?
If you have to revert.
Yeah, revert your trademark, and how does that happen? I don't know, like
what? Revert your trademark.
Yeah, we'll have to see if Jody's going to give us more. Oh, renew it. Oh, renew your trademark. Yeah. Yes, you do every 10 years.
Every 10 years, but if you're not going to use it, sometimes you trademark things that you're stopped using. So if you're not going to use it, then you don't need to renew it. There are a lot of big companies that have over 4,000 of trademarks. They have so many unused trademarks that each year they're renewing it, and they're just wasting money on that. So that's not necessary as well. So as long as you're actually using that trademark, yes, you should renew it. And trademark is forever. As soon as you renew it, yeah, it's basically, it goes down generation after generation as long as you renew it and you use it. In commerce.
Renew it and use it. So let's say you don't use it for 2 years, but then you start using it again, but it's still within that 10-year mark. Do you have to do anything differently?
No, but in the States, between 5th and 6th years, when you have filed for a trademark, you need to file for a proof of use between 5th and 6th. So the trademark office actually checks up on you that you're actually using the trademark in commerce.
Got it. And yeah.
Between 5th and 6th year, and you have to file it in there. If you don't, then it gets expired.
In that 5th and 6th year. That makes sense. Yeah, Elke from Germany is saying it's very difficult in Germany to apply for a word, as long as for a word as a trademark. A logo sign is easier to register. They can easily deny your word. She had that happen to her once. So yeah, yeah, go ahead.
Yeah, there are 3 ways you can trademark your brand. So a word mark, figurative, which is the logo, or combined, which is the name with the logo, right? The figurative one. So a word mark, yes, it could be more difficult to trademark it if there are similar brands in the market. And if it's just one word, then it's definitely more difficult. However, I know a way. If you send a European trademark instead of just a German one, they don't check it. They don't check it. So the government, EU IPO doesn't check it. It's up to the brand owner to have a monitoring in place to, check that. So they don't check it.
Yeah.
So in this case, if you want to have that in place, then yes, you just send an EU application, but make sure you're operating in 2 to 3 markets in Europe then.
Well, that's fascinating.
Plans.
Yeah, or have plans to do it. Roya, that's so fascinating. Again, why I would say why to use a firm like yours is because you have the expertise and you have had the experience of knowing how to work through what is in place and the better way to do it, that we don't have to worry about it. Jody has questions about how much it costs to have someone like you renew it. And then she just went straight to, she needs your services. So we'll connect the 2 of you afterwards. Yeah. Yeah.
Of course. We land back on, again, customize, because depending
Right.
on what strategy, we put a strategy, and that's what's most important, the strategy. Because I said I would never go to Germany and just file for that word. Depending on the search we
Mhm.
find, we would go through Europe. So it's the strategy then. And I have actually spoken to clients where I gave them this information. They went and filed for it in the country,
Mhm.
and they came back to me. They came back to me and said, we didn't get it. And I was like, I told you.
Yeah.
And they just wasted 1,000 euros. And then now they're going to do an EU one. So it's just like, sometimes, I understand being stubborn and trying to do the cheapest way sometimes ends up being the most expensive way.
Almost always. Almost always. Yeah. I worked in nonprofit for 25 years, and I had a saying, free is not always free. When people give you, donate things to you, it sometimes costs more. Yeah.
Exactly.
All righty. So we are at the top. Oh, Elka is saying wordmark is not only because of other trademark similarity, it's because you can't simply register a single word like sister or simply your name, because you can't own a word.
Descriptive.
Right. You can't own a common word use like a family name. Yeah.
In what she's speaking about, I understand that, but it's kind of like Apple. They got that word registered in a tech sector, right?
They
Because
did.
it doesn't mean anything. It's not generic. It's not descriptive. But if they would want to protect that in the restaurant business in clause 43, they would never get it. So it depends on which clause that person. For example, sister rocking. Yes, I mean sisterhood in education, that could be, and it's just women in that group, then it's descriptive. It's describing exactly what you're doing in that field, in that sector. So exactly, that is how it is. But if it's another sector, then you can.
Right. And so that's what gets interesting, because we've even talked about when people want to do like t-shirts and start selling like logos on things, when you have to register within those sectors also. And that's sometimes where you can bump into some competition that you wouldn't have had in another sector.
Normally getting a trademark for just printing on a t-shirt, that is very difficult. It's the same with books. Trademarking the name of a book, it's the same. You need to have a brand associated. It needs to be a brand. It can't be just a book name and you want to use that. So it needs to be a brand associated with the whole product.
Books are fascinating because you can Google a title of a book and you can have a whole bunch of authors that have written that same titled book. Yeah.
Exactly. But if it's a brand connected to that book, then, it changes the whole dynamic, because now you're protecting a brand. It's not the title of a book.
So Roya, what I would say about your firm is it's more, and this is what you've been speaking to. Your firm is more than legally protecting our brands. Your firm really is about strategically planning the future of our brands. So it's not just that we come to you and say, we need this. You actually respond back and give us more, I would say, quicker routes to get to where we want to be in the future.
Exactly. We operate on proactivity and holistic approach. So we take into account the whole business entity. It's not just the legal part that you need to look at. You need to look at the whole business in whole, right? So, and we tell you, we are very transparent. If something we cannot protect, we tell you that is a descriptive name, that is a generic name. We will never get a protection for that. Or there are already existing brands. So it's just a waste of time to protect that name. So exactly, it's very strategically based.
Yeah, I love the holistic. We are actually coming up on the top of the hour. I am shocked at how fast this went. How can people find out more about you?
They can find me at sayadilaw.com or all the social media. LinkedIn is my favorite, Roya Sayadi. You can find me there, or at Sayadi Law. So we are on Instagram. Yeah.
We'll put links below. And I know you're super
Yeah.
easy with, if people have questions, they can reach out to you directly, and you're very easy with scheduling calls to figure out what their next steps are.
Definitely. Yes.
Yeah.
I
Is there
just welcome, you guys are welcome to contact anytime.
any final words as we say goodbye for now?
Just take the leap and go for it. Think big, protect your brands. You have life insurance, right? And I mean, why wouldn't you? And you don't have life insurance because you think you're going to feel ill. You have it as a protection in
Right.
case things go wrong. But with brands, it's actually the opposite. It's an asset.
It
So
is
it's
an
not a
asset.
liability only. It is an asset. Just think about that.
The more you protect your brand, the more valuable it becomes.
Yes, exactly.
And
So,
you never
and
go ahead.
one last thing, Coca-Cola's brand value is, I mean, $86 billion is the whole company worth. 33% of that is within their brand value because they have exclusive rights. So imagine adding an extra 30% on your business because the name, the brand, and you have it protected.
That's brilliant. You're getting a couple of hearts and you're getting some thank yous. And I'll just quickly wrap up with Sisters Rocking Courage. This is about us being brave, being courageous, and really thinking big about our businesses and what we can contribute to the world. If you want to learn more and be more closely connected to other women that are kicking it in business, that's what we're here for. Roya, thank you so much. We're going to see what else we can do to connect you with other Sisters Rocking Courage. So thanks for being here today.
Super. Thank you everyone for listening, and thank you, Barbara.
All righty. Thank you.